If any type of bond other than bid bond is in place for a contract, if there's a performance bond, a payment bond, a fidelity bond, and these are discussed in the class on bonding, then if you get to the point of having to do a suspension of work, stop work, a show cause letter, things of this nature because of problems with the vendor, you need to copy the surety on the letters to the vendor. And the reason for that is because, and this will be discussed more in the bonding class if you take that, but companies that issue bonds are putting up a certain amount of money in case something goes wrong. And it's like an insurance company. An insurance company doesn't like to pay out claims. Bond companies don't like to pay out claims. And so what they try to do if a vendor is in problems, a vendor that they have bonded, they will, in lieu of simply paying out money, they will try to either work with the company that has the contract to help them get over the hump and get performance up to par, or they will seek to substitute a new vendor for the vendor that's having problems. And what they do is they have the option of choosing what they want to do, whether they want to simply pay money if it gets to the point of having to collect on a bond, or if they feel it's going to be a lot less expensive for them to just provide additional assistance to a vendor that's in trouble, they will pay the money to assist the vendor. And what that means is if we never let the surety know that there are problems with a vendor that has a bond, they don't have the option of perhaps helping and giving them some more support or seeking to substitute, etc. So what it can come down to is if we go ahead and terminate for default, or if the vendor goes bankrupt when there are indications that there were trouble that could have been dealt with previously, oftentimes what the bonding company will do is just refuse to pay the bond. What they will say is, since you didn't let us know that there were problems in time for us to do something about it, bless you,
thank you.
In so many words, you have abrogated the bond. And so, and what this comes down to a lot of times is by being a nice guy. Because lots of times if you're dealing with your vendor, the vendor will tell you, now you don't have to copy our bonding company or anyone like that, right? You won't do that because that'll be a little bit sticky and we just really prefer you didn't do that. And if you go ahead and don't do that, it can come down to the point that what we thought we had, we don't have. We don't have the assurance that's provided by the bond. And that's doubly bad because bonds cost money. And that money is tacked on to what a vendor is charging you. So if you get to the point of you abrogate the bond by your lack of action, then you've still paid the money for the contractor to pay for that bond, but you're getting none of the safeguards from the bond being in place. So if you're getting to the point that you notify a vendor of problems and show cause and remediation plans, things of that nature, you need to let the surety know. And sometimes, depending upon the exact nature, you might have to go to your Assistant Attorney General to ask their opinion, because it's a difference between what's called a show cause letter, which is a preparatory step to a termination for default, versus a request for a remediation plan. Sometimes even a request for remediation should go to the surety, but that's something you probably need to discuss with your attorney. And the reason why we have set up there, except for a bid bond, is a bid bond only is in effect until a contract is awarded, and that it is superseded by a performance bond. And so obviously, if you're in contract performance, the bid bond has already gone away, so to speak. So that's why we've made that exception, so that you realize that bid bond, this doesn't apply to, but any other type of bond, this is something you need to be aware of. Now in services, most of the service contracts don't have bonding, but if you're in construction, if you're in maintenance, these do typically have bonds, and so that's where you have to be very careful. All right. Gee, I guess I've said that. What a surprise. See handout with such shorty notice that you don't have. We'll try and get you that handout. Maybe it's in the box, I'm not sure. Only applies to bonds, not, okay. This requirement to provide notice to the surety only applies when there's a bond, not to other types of security, such as insurance, such as irrevocable letter of credit, such as lines, things of this nature. If you go to 21060701B, that has a list of around 7 types of security which are acceptable by the state, of which I've only ever had, I think, 2. So it applies to bonds, it doesn't apply to any other types of surety. And I don't know whether I've listed the other ones here. Probably not. Let's see, a possible issue that can arise during the cancel. Okay, bond and insurance issues. We're talking about performance. We're talking about things that happen when a contract is in effect. And one of the things that can happen is when you award the contract, there is a bond or there is an insurance policy. But if you're particularly in a multi-year contract scenario, excuse me, it's possible that during the course of the contract, something will happen with the bond, or more particularly insurance, because a bond should be there for the duration, except that, as we discussed in the bonding class, often it's difficult for vendors to get multi-year bonds. So one of the things that can be permitted is an annually renewable bond. And if that's the situation, then it can come to the point that the surety does not renew a bond for a company. And if that's the case, then we have the situation of what do you do now if it's renewable but it's not renewed. And we deal with that primarily in the bonding class, but that's an issue you must be aware of. And so it can happen for bonds and it happens for insurance. If a vendor doesn't pay, a bond is paid up front, so there's no issue about being paid for the duration of the bond. But since if it isn't annually renewable, then that means it has to be paid again, or the bonding company may just decide they don't want to continue with the risk of whatever it is that they gave a bond for initially. Or maybe the vendor doesn't come up with the money for the second year, whatever the case may be. So then you have a problem with what do you do from a performance standpoint. With insurance, it's not an upfront type payment. Usually it's paid perhaps every month. And so this is where you typically do have more of an issue of insurance that was in place when the contract was awarded, maybe a year or 2 down the road. The insurance is canceled for lack of payment or because they simply don't want to continue to insure a vendor for a particular risk factor, whatever it is. So you have the issue of, number one, finding out about it. And we have language typically in our contracts that say that there must be notice given X number of days before an occurrence of a cancellation of a bond or insurance so that we have some time to try to do something about it. And usually we have requirements that the vendor must come in with a new policy, a new bond within so many days of notice of the cancellation or non-renewal. And the issue is, number one, finding out about it, and number two, holding the vendor's feet to the fire that if there is a problem with insurance or bonding, that they go out and aggressively try to get a replacement policy. And the other thing that we can have in our contracts is, and I've done this at least one time, that in the event a vendor was not able to get a replacement bond, or in this case it was a bond, but I guess it could apply to insurance, what we said we would do would be start withholding a portion of each monthly payment due the contractor to build up an escrow account that would basically have the same value as the bond that they supposedly could no longer get, which is a way for us to help assure that there is something to fall back on, but it actually is more expensive to the vendor than the bond to begin with, because the general rule is that they pay 1% to 3% of the value of the bond to get the bond. So if there's $1 million bond, they're typically paying $10,000, $10,000 to $30,000. I think that's 1% to 3%. So, and obviously $10,000 to $30,000 is money, but it's a lot less money than $1 million at face value itself. So that's why it's an issue if they can't get this, because you're getting $1 million of protection for maybe $10,000, $15,000, $20,000 of expense. So what to do about such situations is detailed in the one-day insurance bonding class. So in so many words, what we're telling you is we're not going to go into a lot of detail now because we go into the detail in that class. But it's just something you need to be aware of. And hopefully we'll take the class when it's ready and offered. Contract disputes claims. And I guess I'll ask any questions on the thing that I didn't cover and I told you I'm not going to cover. But you could ask a question. All right, you're saying, nope, move on. All right. Contract disputes and claims. Most contract disputes are handled informally. So most of them don't get to the point of a formal claim or getting a formal answer from you as the procurement officer or going to the Board of Contract Appeals. Maybe not utterly satisfactorily to everyone's standpoint, but at least they are resolved in some fashion. So either one side acquiesces to the other side's interpretation or both parties compromise to some degree in the interpretation. Often when you have these type of situations where you have a dispute that is handled informally, the result is a contract modification that memorializes or formalizes what you agreed to in lieu of an actual claim or an answer to a claim. And often the impetus for the modification is to avoid dealing with a formal claim. Neither side typically wants to get involved in a protracted legal situation where the vendor is hiring an attorney to represent them, and we are taking our time, the time of the procurement officer, the time of the assistant attorney general, often the time of the program person or contract manager. So we have the time issue on the state side, and we have time and usually lawyer fees on the vendor side, and all this multiplies if you go to the Board of Contract Appeals. And so generally, it's like any type of a lawsuit. If there's a settlement, it's because both sides figure that it's better to settle something and get it out of the way than to risk losing when it goes further, plus the expense of getting to the point of perhaps losing. And so often you have this compromise from both parties that results in a modification, so then you no longer have this issue in dispute. You have resolved it. But what you try to do is avoid even getting to points of dispute by having the procurement process done properly with getting clarifications and making sure as much as you can that things are very clear-cut before you get to the point of performance of the contract, so that you hopefully don't get into dispute situations. You try to avoid them, you don't always do it. And there's a correlation between how well you do the procurement phase and how well you try to make sure that you've eliminated ambiguities and you've gotten questions from vendors and you've properly answered those questions and you've gone through oral presentations if it's evaluated procurement. And the better you do that, the more likely that you're going to not have problems in the performance stage, at least from the standpoint of lack of understanding of what both sides supposedly have contracted for. So let's see, often the impetus is to avoid dealing with a formal claim. This is okay as long as it's obvious that the state is getting value for the modification, or there is a latent ambiguity with no meeting of the minds under the current contract wording. So going back to these two issues right here. We've talked a number of times about the issue that you have this constitutional prohibition, state constitution, that says that you cannot modify a contract to give them more money without more value, and the modification with the more money must be commensurate with the additional value we are receiving. So keeping that in mind, we are not supposed to do a modification that to virtually anybody appears like we're giving away the store, so to speak. That we're doing this modification to placate the vendor, but we're actually paying them more money, and for the most part, we're not getting anything for it. There has to seem, at least on the surface, like if we're paying more money, and hopefully we can do a modification that doesn't involve money, but if we are paying more money, it needs to at least appear that whatever we're paying is appropriate for supposedly the certainty now that is in the clarification. And if it appears like we're just giving money away to get peace with a vendor, then to the extent that that is recognized by the procurement officer shouldn't agree to it. To the extent the assistant AG can recognize that, the assistant AG shouldn't approve it. If it comes to us or a control agency and it appears to us that that's the case, we shouldn't approve it, so that hopefully with those various safeguards, we don't go ahead and give away something just to placate a vendor, when the bottom line is we should just hold their feet to the fire and make them do something. And the one thing, if you took the planning class, and I may have mentioned it in this class previously, why this is up here, and we talked earlier on the first day, one of the concepts of contracting is you need a meeting of the minds between the parties to a contract. Both parties essentially have to have a relatively similar understanding of what was being contracted for, what the vendor thinks they're contracting for, what we think we're contracting for. And if you get to the point that it appears that even though we've gone through this process, that we have this differing interpretation, the thing that I have mentioned in planning at the very least about ambiguity is the rule is, and I think we did have that the first day also in this class, a latent ambiguity means a hidden one that was not obvious, one that you really could not reasonably have discovered before the contract was entered into, so that it only becomes apparent somewhere in the performance of the contract when we ask for something perhaps and they say, wait a minute, the contract doesn't call for that, and we say, yes it does, and they said, no it doesn't, and that's when we find out that some point that we thought said one thing, the vendor thought meant something else, and we both get to the point that, gee, until we got to this point in time and had this issue now come to the forefront, neither one of us knew there was really an issue with understanding. If there is this hidden or latent ambiguity, the rule is the interpretation of the vendor is the interpretation that will prevail if this goes to the Board of Contract Appeals or beyond that to a court. So that's why if we make a determination that there was a latent ambiguity, then there's more leeway in what we can agree to in a modification, because we know that if that's our conclusion that this is a latent ambiguity, if there were a claim, that would be the interpretation of the Board of Contract Appeals, which means we'd lose anyway. So if we figure out we're going to lose anyway, that's a reason to come to a mutually agreeable modification to perhaps pay some money to get out of the ambiguity. But hopefully we don't have many situations where we have that. But that's a concept, and that can color what you agree to if the vendor gives you their evidence of why they had the interpretation they do, and you work with your Assistant Attorney General, and if you both agree, gee, now that I see their standpoint and I see their explanation, it has a lot of credibility. And if that's what you think, you're going to be more agreeable to various things to come to a modification. If it's not a latent ambiguity, you're not going to be highly agreeable. So that's where that comes in. A claim is a complaint by a contractor or procurement agency. Either one can file a claim related to a contract except for real estate leases. And most of you don't have anything to do with real estate leases, so we're talking about contracts. Either party to a contract may file a claim, but the vast majority of claims are filed by contractors against the state. Typical contractor claim reasons. Ambiguity, and that probably is the single biggest reason why there's a claim, because they at least claim there is ambiguity. And of course, it's always a hidden ambiguity when the vendor feels that it's not in their favor. And they will argue where something that is very obvious wasn't obvious. So, number one, ambiguity. We talked on Friday, yes, Friday it was, the 3rd, about variations in estimated quantities. When we talked about the fact that if you have a fixed price contract with an estimated quantity, and there's a variation. We talked about the range that you could go typically 25% above or below the estimate, and beyond that, either party was entitled to an equitable adjustment. Equitable adjustment means we can pay more money, or we take money away from a vendor if it's in our favor. And even though there is the right to do that, there's always the question, well, what is equitable? Equitable means fair. So it's fine to say, yes, we agree that there is more than a 25% variation. So that means either we or the vendor is entitled to more or less money depending on the circumstance. But now the devil is in the detail. How much is that money? The vendor might come in and say, well, we think we're entitled to $50,000 for this difference in this estimated quantity. And we may say, no, we think you're entitled to $25,000. And then if they don't want to accept 25, they may file a claim because they think 50,000 is justified. So even though there's no question that we have a variation and they're entitled to an adjustment, now we're arguing over how much are they entitled to. So that happens. Same issue with differing site conditions that we also talked about last Friday. When you start digging the hole to put in something and there's not supposed to be a water line or electrical lines or a natural gas line where the vendor is digging, and yet when they dig, they cut through lines and now there's problems. Sometimes they may damage their equipment. At the very least, it typically causes a delay that now they can't continue the work while someone else comes in and takes care of the utilities, or even they might be authorized to do the work. But the question is, now that we have this, how much is the delay worth? How much is the extra work worth? So we may agree there's differing site, but we may not agree on the value of the consequence of that.
Yeah, at Spring Grove, we ran into, they were putting in a fence and they were digging the various holes and they ran into a solid granite stone and wound up having to.
And they probably
spend
only
days.
dug it, what, about 5 feet,
That's
6
right,
feet?
That's right. And they've spent literally a week and a half of additional time digging those post holes in that granite.
Did you all hear what he said? Because they had a situation of just putting in a fence. And normally a fence, you might put the supports down 5 feet or something like that, and they're going along and they're digging in dirt, and at one point, and I don't know how extensive it was, they hit granite. Big difference between digging in soil and digging in granite. And you said it took them an extra week and a half?
About a week and a half to get the remaining 4 or 5 post holes.
That is a differing site. If they were led to believe that they would encounter normal soil and there was no indication they would have to be digging in granite, then they are entitled to money under a differing site condition. So they're entitled to the value of that 10 or so extra days of effort to do that. Or the other thing that could have happened aside from that is maybe once they encountered that situation, perhaps you'd have said, all right, move the fence. But then it depends on how extensive the granite was.
Right.
And did you need it right there, or even if you could move it 5 or 10 feet, maybe 5 or 10 feet still is in a point where there's granite. So the reason why we have these things is vendors, this concept of risk. If vendors don't know what they're getting into, and if they're the one that's on the hook for whatever expense, a vendor that wants to stay in business, which most of them typically want to do, is going to build in a hedge for a risk factor if they don't know what they're getting into. And that's why we say the concept is, if it's something where you have reason to believe there might be risk, oftentimes the best thing to do is to take the risk on the state so that we're only paying for the risk if it actually materializes, versus a vendor charging for it if they have the risk and they get the same amount of money whether it happens or doesn't happen. That's what these two clauses are designed to do. Transfer risk from the vendor to the state so the state only pays for it if it happens. And if it happens, then what's it worth? And you can get into a claim situation because of that.
Situation, but we were providing services, right? And we we asked the state to give us more services than less, but we didn't need more services. But we put in the contract for more services, but we were told not to do that. You know, just like what you
Put in
said.
the contract for more serve? I don't
Meaning,
understand.
say if somebody is going to be coming to the hospital like 2 times a week, but we
Okay.
thought maybe we may need them 3 times a week.
All right,
So we put in the contract for 3 times a week,
okay.
you know, which was
Mm-hmm.
a little more than what we had expected. But then, you know, when the next time the contract came through, they said, you know, why did you ask for more? You didn't really use it.
All right.
You know, we rarely do this problem.
Let me repeat this because I know none of you heard that. What she was talking about is a situation, because I had difficulty hearing myself.
I know, it's just more.
That's all right. So there was a provision in a contract that a vendor was to provide work at a facility typically 2 days a week, but you had the right to ask them to come in 3 days a week.
No, we put in the contract that we need him for 3 days a week.
And they didn't use it.
And we didn't use him.
So the contract actually said come in 3 days a week.
Right, but we didn't use 3 days a week.
So if it said in the contract come in 3 days a week, why did they not come in 3 days a week? Did it say up to 3 days?
Up to 3 days.
Up to 3 days.
3 days, yeah.
So, and you would tell them on a week-to-week basis or something like that, whether it's 1 day, 2 days, 3 days.
Right.
All right, and what that illustrates, obviously, if you have in a contract that a vendor could be required to provide services 3 days a week, and I presume this was fixed price?
Yes,
Fixed price. So they're not getting paid by each day. Because if they get paid by each day, then if it's 1 day, they get paid for 1. If it's 2, they get paid for 2, etc. But if it's
only
a
for the services that we provide.
what I think I understand is
Yes.
there was a recurring need for a vendor to do something at a facility 2 days a week with the possibility that the service might be needed 3 days a week.
That's correct. That's it.
There was a price,
Yes.
a fixed price apparently for 2 days.
Yes.
And if the vendor had to come in a third day in any week, then there was a price to come into for the third day. So what that illustrates is instead of just saying, give me a price to come in up to 3 days, when you didn't know whether you'd need the third day, you got the price for what you knew you were going to need and a price if you needed the third day. So that's an illustration of how the pricing was done in such a way that the vendor didn't have risk. They got paid if they needed to do the third day, and the agency was only paying for the third day if they needed the third day. Now, from my standpoint, even if you didn't need the third day at all, there's no reason not to have that provision in there if there's even the possibility you would need it.
Okay, that's fine.
As long as you had that provision in there and you had a price in there and you didn't guarantee you'd ever use it,
Yeah.
it's like, why not? It's covering a contingency that might happen. That's a smart thing to do from my standpoint. So, good thing. Let's see. I think I went backwards. Unreasonable refusal to accept a deliverable. We've talked about acceptance standards. A number of times I said it should be very clear what a vendor has to do in order for the state to accept a deliverable as being properly performed. If you haven't done that, if you have not put the performance standards in, then it's a possibility that if you say to a vendor when they think they've done something and you say, no, we don't agree, we don't think you did what we wanted, they might say, well, from our standpoint, we have met the standard. And so your refusal to accept that deliverable and thus the refusal to pay money, we're filing a claim now because we think we have met the standard. So if they don't think that you are correct in your refusal to accept something, they can file a claim because they feel that you're just being obstinate, you're just trying to extort, who knows what they think. But the bottom line is it all comes down to money. So that's a reason why they can file a claim. So it comes down to how clear was your acceptance standard, and if it was clear, if they file a claim, then you should win. But if it wasn't clear, then you have to, maybe you're going to have an issue here, and maybe you have to pay money because of it. And the final thing that is frequently is where we say something is liquidated damages, and even though we have the amount of the damages in our contract, and even though they allegedly have agreed to that by signing the contract, it still can come to the point when you start assessing the damages and it starts actually mounting up as far as real money being withheld from a vendor. They may say, wait a minute, we think this is actually penalty and not damages, because we don't think that the amount of money that you are withholding for these damages is commensurate with the amount of harm. We think it's excessive. And so they may file a claim that says, we think it's a penalty, and as we said before, if it's a penalty, it's unenforceable, and so that's one of the things they can do to try to avoid paying these liquidated damages that they claim are penalties. So these are typical reasons for claims from a vendor. Tips regarding claims from members of the Board of Contract Appeals. Did anybody here attend the July 31, 2009 Board of Public Works Procurement Seminar at the Maritime Institute? If you did, there was a breakout session that was done by 2 of the 3 members of the Board of Contract Appeals. And they had, if you attended that session, they had a sheet of paper. On one side, it had words of wisdom regarding protests, and on the other side, it had words of wisdom regarding claims. Because both protests and claims that are appealed go to the Board of Contract Appeals. And protests, of course, happen before there's an award of a contract, because a protest is against the awarding of a contract. A claim is by the vendor who has a contract about some issue that comes down to money. And so these are a couple things that I took from that seminar of 2 of the members of the Board of Contract Appeals. And the title for the side that had about the claims was Contract Disputes, We Can Work It Out. So that was right at the top. And again, these are quotes. Contract disputes are usually about money. Most can and do work themselves out. Don't allow yourselves to get into a fight with a contractor. Stay cool, stay calm, stay professional. Even if the other guy isn't, chances are it will work itself out. And this really seems strange when I'm sitting there and you have 2 members of the Board of Contract Appeals basically saying, just cool it. Just take it easy. Don't get excited. It's just money. And when it's just about money, then at some point we can get to some resolution about the money. So if we're going to get to a resolution about the money, take it easy. And even if the vendor is more excited because they're the one that typically feels they're out the money, just you at least just be calm and don't take it personal and just try to work it out. Hopefully before it gets to us at the Board of Contract Appeals, but even if it's not worked out before it gets to us, we'll work it out. So just take it easy. And I'm thinking, well, number one, it's nice to hear that, but number 2, easy for you to say. And the other thing they had on there, they had more points than this, but these are a couple I thought noteworthy to bring in here. Procurement clarity. To the extent possible, bid documents and all communication should be as clear as possible. Misunderstandings and non-clarity can lead to protests. And my reaction was, duh. Yeah, okay. And I think I've said that probably about 200 times. Make it as clear as you possibly can, because if you go to great efforts to make it clear, to go through the process to make sure there's understanding, then hopefully you don't get to misunderstanding because of non-clarity. So that's what we're trying to avoid. The same logic applies to help prevent claims, that if it's clear, etc., it will minimize the instance of claims being filed. Rules for filing. So I'm just going to tell you what the rules are for these things that hopefully you won't have to encounter. A contractor claim must be filed in writing with the procurement officer. So they must know who the procurement officer is. They must submit it in writing to the procurement officer. The filing of a claim electronically is not permitted unless specifically permitted by the terms of the contract. In the planning class, we had a handout which is like a page and a half about electronic procurements authorized. And I don't think we've given it out in this class. But that is a recommended clause that DBM has come up with, actually our lawyers have come up with, that tries to pinpoint what transactions can occur electronically, meaning by email, versus things that have to be the regular U.S. mail or courier with a hard copy, etc. And generally, one of the things they say is that protests and claims cannot be filed electronically. So if you adopt this recommended clause that we have, then it'll specifically say has to be in writing. And one of the reasons to do this is, very frankly, to make it more difficult for the vendor to file protests and claims. If they have to do it in writing and they have to have it delivered, that's more difficult than just clicking your finger and sending an email. So, but these things are substantive. If there is not a specific provision in a contract that permits claims in this regard to be filed electronically, they can't do it. And I have actually been in a situation not involving a claim but involving a protest. And I will tell you this story and tell you at the time I thought it was unfair to the vendor. Sometimes I think we do have to be fair. But it was a vendor filed a protest electronically. And if you know the time for a protest, it's 7 days from the time the basis for the protest was known or should have been known. So something like 2 or 3 days after a vendor was told it didn't win a contract, it sent electronically a protest to the procurement officer. We had the thing something like 4 days before the 7-day period was up. And I thought, and this was actually before we had this clause on electronic procurements authorized, and I had a little discussion with my Assistant Attorney General, was, okay, well, now that we know that this vendor wants to file a protest, don't we have some kind of responsibility to go back to them and say, I know you're trying to file a protest, but we can't take it electronically, so if you want to file it, give it to us hard copy? And the Attorney General said, no, we're not going to tell them the fact that they have not done something properly. We'll wait until the 7 days are up, and then we'll reject it because it was not properly filed within the time necessary. And I said, that kind of smacks of just not the right thing to do. Right. They're trying to file a protest, and even though I don't like protests, I'm certainly not the biggest fan of protests. I think, well, it seems like it's just fair if we know they're trying to do it and we know it's wrong, to let them know it's wrong. Don't you dare tell them it's wrong. And so I listened to my attorney. We didn't say a word. And then after 7 days, we rejected it as being improperly filed within the necessary 7 days. And they took umbrage to that and filed an appeal to the Board of Contract Appeals. And our attorneys simply wrote up the response that said, the requirement is that they cannot file it electronically unless the state specifically says they can file it electronically. We did not say it could be filed electronic, and so they didn't do what they're supposed to do, and the Board of Contract Appeals summarily rejected the protest because it was not filed hard copy within 7 days. And I still, even though we won, I'm still like, it just doesn't smack of fairness. And so, and I don't know whether it was because of that, but after that is when the attorneys came up with this electronic procurements authorized clause, which I was very happy because now it said in great detail what was permitted electronically and specifically what was not permitted electronically. And from my standpoint, if you tell vendors, then fine. I'm all for holding their feet to the fire if we've told them what the standards are. So that is substantive. If it's not allowed to be filed electronically and they file electronically, they're going to lose, just on that basis alone. And the term filed means receipt by the procurement officer. And if it means hard copy, that means a hard copy receipt by the procurement officer. In the procure class, we talk about protests that are supposed to be filed with the procurement officer, and we go through a couple scenarios of actual situations where a vendor tried to file a protest with the procurement officer but sent it to the wrong place. And we went through, what do you do? Does the procurement officer go and get it? Does the office that received the protest improperly, delivered to the procurement officer, and we went through a number of these scenarios to discuss what are the obligations and lack of obligations or the proper thing to do, and the same issues apply to claims, except in a claim they should know who the procurement officer and who they're filing it with. And the general guideline is it's their responsibility to get it to the right place. And if it goes to someplace other than the right place, if you want to go and get it, or if somebody wants to put it in the interoffice mail or deliver it from where it was received to the procurement officer, that's fine, but there's no obligation that happen. And you can just as easily just sit there, and even though you know there's a claim that somebody else has, if it's not the procurement officer, you could sit there and wait and just wait until the 10 days are up, because 10 days is a time period for a claim, and then just say, sorry, not timely filed with the procurement officer. Again, whether that's fair or not, I'm not sure. I think in fairness that if I know something is out there, and I don't like to get in the situation of I know that something's wrong, but I don't say anything about it. But that's the requirement, so you don't have to. All right, a claim must be timely filed unless the law or the contract prescribes a lesser period of time the contractor must file. Oh, the 10 days, excuse me, the 10 days I just mentioned is not right. That is the time period to appeal a denial of a protest. For a claim, it's 30 days. Every now and then I have to remember these things myself. That's why I put them in writing, so I can read them. Notice of claim. Within 30 calendar days after the reason for the claim is known or should have been known, whichever is earlier. So, and I want to draw a distinction between a notice of claim and the actual claim. A notice of claim simply means we are going to file a claim. We're telling you, we're putting you, the state, on notice, the procurement officer, on notice that a claim's coming. And it doesn't, perhaps they've given you all the detail at the time they give you the notice, but typically it is simply like a one-page or a half-page notice that says, we're going to file a claim on this issue. And then, having given the notice of the claim within 30 calendar days after the reason is known or should have been known, whichever is earlier, they have to file the actual claim either with the notice or within 90 days if it's a construction contract, or 30 days if it's a non-construction contract. So you can see this is a much longer time frame than involved in protest, when it's 7 days to file the protest and 10 days to appeal the protest. Here they have at minimum of 120 days for construction. If you have 30 days for the notice and then 90 days before the actual claim, and a minimum of 60 days possible for non-construction contracts to just file the claim. And that's what they think they're entitled to and why they think they're entitled to it. Notice is the half page. The claim might be 10, 20 pages of justification for what they're claiming the value. The procurement officer may not. So again, we're talking about the rules. And the first one was the rules for filing. Now we're on to rules for the response by the procurement officer, because the procurement officer is the one who responds to a claim. And it's not the contract manager. It is the procurement officer. That's why if there's a claim, and if the claim goes to the contract manager, and the contract manager is not also the procurement officer, then the contract manager needs to notify the procurement officer, and then you have discussion about whether you actually physically take the claim from the contract manager or wait the time period and say, nope, too bad, it's late, won't accept it. We've gone through that. But if you have it, the procurement officer, you may not consider an untimely filed claim. May not, cannot, not permitted to, prohibited. And there was actually a protest one time on the words may not, because the vendor claimed that since may is a permissive word, if you take may by itself, it means you're permitting something. Their argument and some of you have already started laughing, but the argument was that we changed the slide before we talk about the answer. The argument was that since it was May, that the procurement officer had discretion as to whether or not to accept it more than 30 days after the time when the basis was known or should have known, because May is a permissive word. And so there was a decision of the Board of Contract Appeals that says, no, when you have a not after a may, that doesn't mean it is something that may be done. It is saying something that may not be done, which means it's a prohibition. And the things that get protested and claimed sometimes are funny. Yes?
I was just going to say, along those lines, one of the RFPs that we had to do, which was for services, not a tangible
Right.
project, we had to go, that was one of the things we had to do. The procurement officer told us we had to go through and change all of our mays to shalls to make them more definitive.
Shall not to directive.
Well, we cover that in the planning class. And I will say, if you're in specifications, may and shall don't mean the same thing. If you may do something versus shall do something, that is a huge difference.
We had to change all of them.
Depending, what we say in planning is may should only be used if it is talking about something the state might do or might not do. But obviously, if it's a requirement for a vendor to do, then you're using must or shall or is to or something like that. But yeah, as a requirement, may doesn't cut it. Because that's something where the vendor can come back and say, well, if I may, that means I may not, so I choose not to. Still pay me the money that I quoted for whether I might or might not do it. And I'll choose not to do it and take the money. Thank you. Yes?
Is there a real difference whether you use shall or will?
No. Oh, shall and will?
Yeah.
Shall and will, yes.
Okay.
Usually the answer is shall and must. Shall and must, no. Will, again, in the planning class, we don't recommend the use of the word will in terms of a requirement from a vendor. And what we say there specifically is will should only be used when it is indicating something the state will do. And I know some people think that when you say the vendor will do something, and I'm not saying if you use will in that context, it probably still will be interpreted as a requirement, but that's something where I would go along and say I would change the wills to a shall or a must or something like that, because will just has too much connotation of permissiveness. Let's see, shall investigate. So the procurement officer, if it's not timely filed, hard copy in your hands, but within the 30 days for the notice and the additional days for the actual claim, you won't do it. But if you do have it in timely, you will investigate and review the facts pertinent to the claim. Now, hopefully, you don't have to do a whole lot of investigation. Hopefully, you or the contract manager knows what the facts are, and even if the procurement officer doesn't, the procurement officer simply goes to the contract manager and says, okay, tell me what's going on. Here's what the vendor is saying. Does it hold water? Do you have anything in your files that it obviously repudiates it? Do you agree with them? Maybe it's the opposite. Maybe the contract manager says, yep, everything they say is true. If you agree with them, then you uphold the claim. Usually I don't think that's what we do, but you'll have to see. But you shall investigate, review, and if necessary, you can request additional information or substantiation. You can go back to the vendor and say, okay, you've given me a certain amount of information, but here's the additional information I need to really make a decision. Or you go to your contract manager or you go to some other source for information that allows you to make a decision. You shall seek, shall.
Very good.
Not will, not may. shall seek the advice of the Office of the Attorney General, because the Office of the Attorney General has to approve the answer to any claim, just as they have to approve the answer to any protest. You can, but are not obligated to conduct discussions with the contractor about the claim. So you can actually bring them in, or by email or by phone, discuss and go through questions again, or you can bounce things off them, or whatever the situation is. You just get more information pertaining to the claim if you think is appropriate. You will respond to the contractor within the appropriate time frame, and the appropriate time frame is with the rolling of the drums, please. If it's a construction contract and it is an accelerated procedure claim, which I don't know what an accelerated procedure claim is for construction. I don't know construction, so if you're involved in construction, you probably know what this is. But I think all the vendor has to do is, I think it has to be within a certain value, and the vendor has to request it under accelerated procedures. And I think if they do, they're waiving the right to do something. But anyway, if it is an accelerated procedure claim, you as the procurement officer must respond within 90 days if it is a construction contract. If it is not under an accelerated procedure claim, you, the procurement officer, must respond within 180 days. And if the contractor agrees in writing to something beyond these two time frames, depending on which is appropriate, then you can do it within the time frame that the vendor has agreed in writing that you can respond. So this is your obligation to get back to the contractor to tell them, yes, you agree with the claim, or you partially agree, or you reject it and deny it, whatever the situation is. Now, you come to a kicker here. And this actually was settled by a decision of the Board of Contract Appeals. That's how we know this is a correct answer. The failure to reach a decision within the appropriate time frame shall be considered a denial of the claim for the purposes of the contractor filing an appeal. There was a situation 5, 6, 7 years ago where, and I think it was a construction claim, where the procurement officer did not respond within 180 days. And I don't know whether it was 200, 250, but it was something beyond 180 days. And the contractor waited until the procurement officer responded. And the response from the procurement officer, when it finally came, was a denial. And so once the contractor got the denial, the contractor filed an appeal of the denial. And the decision of the Board of Contract Appeals, and let me go to the next slide. Well, let me see. All right. Decision of the Board of Contract Appeals, they have, probably it's in a couple slides from here, I think they have 30 days from the date they get notice of the disposition of the claim to file an appeal. And in this particular instance, whatever the time frame that the procurement officer took to respond was more than 30 days beyond the 180-day time frame. So when the vendor responded within 30 days and appealed the decision to the Board of Contract Appeals, what the agency did, and of course you'll love this, is say it was a late appeal because it wasn't filed within 30 days of the 180th day. So the vendor waiting until he got a decision from the agency meant that he now was precluded from filing an appeal because it was more than 210 days from the date the contractor filed the claim. And is that fair? Well, the Board of Contract Appeals said it was, so that's the standard now. So now what we are required to do, and I think actually the language in the clause having to do with claims was changed after that to put vendors on notice. So it is now in the actual wording that says, in the event you don't have an answer if it's construction within 180 days, you still must file a claim within 30 days from the 180th day from when you filed the claim. So they know a non-answer is essentially a denial. So at least that gets some element of fairness back into it because, again, once you put vendors on notice, it is their responsibility to read the clauses. That's what they're in there for. That's why the words are actually, someone took the time to construct them because they have meaning. So if they're in there, we put you on notice. I'm much more comfortable with holding vendors to the realities of something where we've told them what the rules are. Now that pertains to construction. So, yes?
Does this also mean any longer period to which the contractor agrees in writing also included in that? If they agree in writing for 210 days, does it mean that they have to file after 180 days?
That is a question I never thought of since I don't deal with construction. I would assume the answer is yes.
After 180 days, they have to file?
Well, I don't know. I don't know whether, just trying to think of this logically, which may have no bearing in this at all. But I'm thinking if it is permissible to have a longer period that the contractor agrees to, that the 30 days that they have to file the appeal needs to be within the longer period. So if the contractor agrees to, let's say, 220 days, I'm thinking that it would have to be now within 250 days. But I can't tell you I know that conclusively. And those of you who deal with construction, which I guess is the back table, that's something you may have to think about. And do none of you deal with construction? Some of you do and some of you don't. So, take a note of it. For the rest of us who don't deal with construction, we don't care about you. We go to this other thing that says there ain't no rules. If it's not construction, there are no time frames for responding to a claim for a contract that is not a construction contract. But what it does say should be an expeditious response. And actually, that is the same standard for responding to a protest, as expeditiously as possible. And one time I responded to a protest, it was either 7 months or 9 months after I got it. I forget which one it was. And when the vendor appealed my denial, and this was a protest, not a claim, within 10 days of my denial, they appealed to the Board of Contract Appeals. One of the points they appealed was that I had violated the requirement to respond as expeditiously as possible. And so that was another justification of why they felt they should prevail on their appeal. And so I had to now answer why it took me either 7 or 9 months, and my answer was very simple. I had 151 protests that I had to deal with in that period of time, and this particular protest was 11 pages long and was invoking the U.S. Constitution with a number of the points of protest.
Good.
And what we said was, so our attorney had to research issues of alleged violation of what we did versus the U.S. Constitution, and trying to deal with constitutional matters at the same time as we were dealing with 151 protests, which I have the record, the most protests ever from a single procurement, because that was one procurement that resulted in 151 protests.
Wow.
In the same time frame. So the Board of Contract Appeals specifically wrote that under the circumstances, they thought the response was as expeditious as possible. So, and we won on the meritorious grounds also. We didn't violate the U.S. Constitution, I'm happy to tell you that. Now, one of the things you can have is a negotiated settlement. So we're talking about the response. Now here's what the responses might be. One of the things you can do is negotiate a settlement of the claim. And someone remind me when we're in 10 minutes in this break time. Unless you want to go work through the break, just let me know if you do. Yes, I know that there was an outpouring of consensus for that. A negotiated settlement, if it happens, must be in writing, must be approved by the reviewing authority, that is your agency head or the designee of your agency head, must be approved by the Office of the Attorney General, must be consistent with the budget and applicable law. Obviously, you can't agree to pay money you don't have, and you can't agree to do something that's in violation of a law. And hopefully, based upon the review by these two entities, you will never get to something that is in conflict with the budget or some other law. Supported by a written determination of the procurement officer that the settlement is in the best interest of the state. Obviously, I don't think you would enter into a settlement that wasn't in the best interest of the state. So, but you must have a statement that this is construed to be the best thing for the state. Must provide for appropriate releases by the claimant, i.e., this is what a settlement means. I'm giving something, you're giving something, and one of the things that you, the claimant, is giving up is you're not going to try to go any further. You're not going to try to go to the Board of Contract Appeals. You're not trying to go to circuit court. You are accepting, just as we are accepting this as a settlement, you are accepting this, and it will extinguish all other claims and issues. Must be in writing. Sometimes based upon a verbal commitment from an agency to take or not take a certain action, a vendor will withdraw a claim or not appeal the denial of a claim. This gets to an issue of credibility. If you tell the vendor, here's what I'm going to do, sometimes they will take your verbal assurance if they believe you and they have faith in you. And they will not require a written settlement. They will instead withdraw their claim based upon what you've told them is going to happen. Now, maybe that means that if it doesn't happen, they can file another claim, and maybe it doesn't. But this does happen sometimes. This solution depends heavily upon the rapport. Pardon me.
I would have thought that would have never happened. Verbal doesn't mean crap.
Well, it comes down to this. The rapport with the contractor. They're trusting you. And even though we talk about the worst case scenario, that you should always go from the standpoint of caution and do what's in the best interest of the state, there are times when you do have this level of trust between yourself and a contractor that if you give them an assurance something will happen, they believe it. And I think if Gary were here at this point in time, he might jump up and might say, I remember the time.
No, the real problem is somebody could retire, change an organization.
Well, it kind of depends on
structure.
how soon this thing's going to
I
happen.
mean, if it happens within 24 hours, yeah.
For instance, Gary was in this job, I think, about, I don't even know if it was 6 months. It might have been something that was going on when he first came into his position, and it had involved a protest. And Gary ended up having discussion, and this is a protest that was filed before he ever started working here. And he ended up talking to the lawyer for the vendor, and in the discussion with the lawyer, supposedly finding out the crux of the issue from the vendor's standpoint, he said, what if we do this? What if we cancel this procurement and do the follow-up procurement in this method, in a different fashion? And if he were here, he could tell you if I'm saying this wrong. I think I remember correctly. And I think he said, will you basically assure me that if we cancel this procurement and do the follow-up procurement in this fashion, that you won't protest us doing the procurement in that method the next time? And supposedly he got a verbal assurance that, okay, we would be satisfied if you did that, if you told us you were going to do that, and we would then withdraw our protest currently. And so that was done, I think, just on the basis of just verbal discussion and verbal agreement. And they followed through and withdrew their protest. Gary followed through and canceled the existing procurement, redid the new procurement, did it in the fashion that he had said he was going to do, and it was not protested.
And probably at Gary's level, that's appropriate. At my level, it's got to be signed off by 73,000 people.
And it just says, we're not saying that this is the typical solution, but it's a possible solution. It depends on, you're going to have this comfort level, and you're going to have to convince your attorney and your agency head that that's an appropriate way to go. And they might tell you, okay, at least go ahead and bring it up with the vendor and see what they have to say. And the worst that can happen is the vendor says, well, no, I'm not going to give you any assurances, and no, I don't trust I want to see something in writing, and if that's the case, you don't do this. So sometimes it can work, I'm not saying the majority of the time, but sometimes it could. So you could have an informal negotiated settlement. That is a possible conclusion of a claim. If you don't have a formal, so we'll go back to the three possibilities. You can have a formal negotiated settlement, an informal negotiated settlement, and if you do not have either of those, if you do not have a settlement of any kind, and the vendor doesn't simply withdraw the claim, which usually they don't do, you have to make a decision. The procurement officer has to get to the point of saying, I agree, I disagree, or I partially agree, and here's what I agree with, and here's what I don't agree with. So you either uphold or deny the claim. The procurement officer is to make a written decision. This decision must be reviewed by the Office of the Attorney General and approved by the agency head or designee. If the contractor wants, and the 30 days is correct, if the contractor wants to appeal the agency's decision, it must do so in writing to the Maryland State Board of Contract Appeals within 30 days of receipt of the decision, or 30 days, here's the other part, after the 180th day for construction contracts if there is no decision by this time. So their time frame is 30 days to appeal a decision by a procurement officer. And presumably they would not appeal if you upheld the claim, they would only appeal if you're denying the claim. Board of Contract Appeals will notify the Office of the Attorney General for the agency involved if they receive a claim. So why don't we take a break now and come back and then discuss this? So if you would come back in 15 minutes.